Are you thinking about setting up a living trust to secure your family's future? Well, you might be making a few critical mistakes that could undermine your whole plan. Stick around to find out how to avoid these pitfalls and ensure your trust works exactly the way you intend it to. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the Estate Planning Guys. Today, we're diving into a topic that, while often overlooked, is crucial for anyone considering estate planning with a living trust. I'm going to go through the 5 most common mistakes that I see people make when they're setting up a living trust and how you can avoid making those same mistakes. Mistake number 1, and this is a big one that I see frequently, is not properly funding the trust. So funding is the process of moving assets into a trust. Funding is just a word that attorneys use to refer to that process of transferring assets into the trust. And if you think of a trust as a bucket that you're going to put all your assets into, and as long as you're alive and you're competent, you're in control of the bucket, you're holding the handle, then if we don't put the assets in the bucket's just an empty bucket and it's not going to do anything for us. So it's really important that you get the assets actually into the trust in order for it to be effective. And a lot of times attorneys will help you with the big things, like maybe they'll help you move your real estate into the trust and maybe your business interests. So like if you own an LLC, for example, they can help you with that kind of thing. But then oftentimes it may be up to you to move your bank accounts, your brokerage accounts, those sorts of things into a trust, because for an attorney, it's difficult to do that on behalf of a client because you have all these privacy laws that keep those companies from sharing information about you. But then when I call and say, hey, this is Mike Smith, I'm calling on behalf of my client, they're like, yeah, we don't know who you are. We're going to need a release signed by your client. And we'll have to have, sometimes we want a special medallion signature on it, all that kind of thing. So it can be kind of tough for an attorney to do it. So a lot of attorneys will give their clients instructions on how to fund the trust. And it's important that you do that. If you set up a living trust, that you follow through with completing it, because getting it drafted up, designing it, drafting it, all that is great. Executing the documents is all fantastic. But if you don't put the assets in the trust, then remember, it's just an empty bucket. So you want to make sure that you follow through with the funding of the trust, putting the assets in the trust. And it's easy to remember your major assets, like your home or your bank account. But don't forget about like your personal property, your digital assets, or any small business interests you might have. Those things are important as well. And that's something that your attorney can assist you with that. That's all relatively simple. You just don't want to forget about anything. And then the other thing is that as your portfolio changes, then you need to make sure that whatever new assets you acquired are also funded into the trust. So it's important to have regular reviews of your trust and the assets that are in the trust to ensure that everything is properly aligned and you've got everything in that bucket so that it can take care of you if something happens. So that's mistake number 1, is not funding the trust. The second mistake that I see people make frequently is failing to update the trust when life changes. So major life events like marriage, divorce, births, deaths, those are things that all can necessitate trust revisions. And so you want to make sure that when anything major like that happens in your life, if you get divorced or you have children or grandchildren, and you want to make sure that they are addressed in the trust, then the trust is going to need to be updated. And you need to reach out and get in touch with your estate planning attorney and make sure that you get those changes made. The second area where changes occur and your trust needs to be updated is when the law changes. So periodically, there are changes in state and federal law that impact your trust and the way it works. And in order for your trust to remain effective and compliant, sometimes it needs to be updated. And we usually contact our clients and let them know about major changes in the law so that we can ensure that their documents are all updated. But maybe your estate planning attorney has quit practicing law or passed away and you don't know anymore. It's important to pay attention to what goes on in the estate planning world. And I don't mean you need to, be reading a newsletter every day or anything like that, but it's just important to be aware of what's going on in the estate planning world with things like the estate tax, the trust code, those sorts of things, just to know like, okay, hey, we need to go check in with an attorney. I know some things have changed and I want to make sure our plan is up to date. The third area where changes occur that necessitate updating your plans is beneficiary adjustments. So periodically, you just want to go through your documents and make sure that your beneficiary designations, whether that's in your estate planning documents or even, if you have something like an IRA or kind of insurance policy that's not a part of your trust, I wouldn't recommend that, but it could happen. You just want to periodically review all those beneficiaries and make sure that they still match up with what you're trying to achieve, who you want to receive the benefits from your trust or your estate, and make sure that, if they don't match up, that you go back to your attorney and say, hey, I need to do an amendment. I need to update my trust so that everything is lining up here the way that I want it to. So that's the second mistake that people often make is they think, oh, this is something I've done. I don't need to ever worry about it again. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. I tell people, think of a trust like a car. If you don't maintain your car, then one day you're going to get in your car and expect it to take you where you need to go, and it's not going to get you there. Well, your living trust plan is the same way. If you don't keep it maintained, if you don't maintain it, then you may find that when you need it, it can't get you where you need to go. So make sure that you keep those plans up to date as things change in your life. Now, the third mistake that we see people make frequently is choosing the wrong trustee. So while you're alive and your spouse is alive, if you're married, you may be serving as the trustee of your trust, or your spouse may serve as the trust after you've passed away, or both of you may be serving as the trustee. But after you guys are gone, there's something called the successor trustee, and that person or entity is going to take over and manage the trust as the trustee. So they're going to take care of making sure that everything is invested properly and that the tax returns are filed and distributions are made appropriately. So it's important to understand what the roles and responsibilities of a trustee are before you just willy-nilly choose anybody to serve as your trustee. You need to choose someone that's capable and reliable, and choose someone that has the ability to get along with others. If you have children and one of them is kind of overbearing and difficult to deal with, you might not want to make them the trustee of the trust, because while they may effectuate what your wishes are, they also may create a lot of discord and kind of break the family up because of the way they approach the job. So you want to be careful and make sure that the person you're choosing is not only capable and reliable, but that they're also able to deal with others well. Now, you could always designate some professional or a company that serves as a trustee to serve in that role. And I'm finding more and more that I think that's a great idea. It can be very difficult for family members to deal with administering a trust. And I have had clients who did great. Their kids did great job administering the trust after they passed away. And then I've had other times where maybe a child was named as the trustee and they just didn't do a very good job of communicating with their siblings about what was going on. They didn't keep great records, and it led to some discord, some conflict, and ultimately litigation. So it's important that you're very careful in making those choices, because that could have ripples that echo down the years. So it's very important making that decision about who's going to serve as the trustee. Now, as I said, you could consider a professional trustee if things are pretty complex with your estate. That's a great idea. Or if you find that the family dynamics you have in your family are particularly challenging, professional trustee might be a good idea. The drawback to a professional trustee is obviously cost. Professional trustees don't serve for free. They have liability as a fiduciary. And so there's an expense in carrying insurance to cover them. And it can be a little bit expensive to have a professional trustee. So you need to consider that, but don't let that completely drive the choice. Because a professional trustee, it can be well worth the money in a situation where there's complexity or some sort of family dynamic issue. So think about who's the right person to serve as a trustee, and consider a professional trustee if there are any issues that you foresee being a problem down the road. Now, the fourth mistake that we see people make oftentimes with living trust is ignoring the tax implications. So proper structuring of a trust can protect your estate from estate taxes and other potentially income taxes, capital gain taxes, etc. There's several key strategies to minimize estate and inheritance taxes. So there can be state-specific considerations. Tax implications vary significantly by state. And so it's really important that you get tailored advice from an attorney in the state where you live. Some states have an inheritance tax, some states do not. Some states have a gift tax, some states do not. Just depends on where you live. So it's really important to get state-specific advice on that. And then trusts can have annual tax obligations. So after you pass away, your living trust becomes irrevocable and it's got to file a tax return. And so there are filing requirements every year. And if you fail to comply with those requirements, it can lead to penalties and increased tax burdens. So it's important that the person serving as the trustee makes sure that any required tax returns are filed and any liabilities are paid in order to ensure that we don't run into any unexpected tax liabilities, any penalties. So mistake number 4 is just ignoring the tax implications. Mistake number 5 is DIY trust documents. So a lot of times folks say, hey, estate planning is kind of expensive. I don't really want to spend money on an attorney. I'll just get something, I can download something off the internet. I can use one of these services and I'll just get something in place. Well, the reality is that estate planning is nuanced and it involves a lot of different areas of law and it varies by state. And the problem with DIY solutions is they often fail to account for specific legal requirements, either in your state or that are specific to you. And oftentimes these documents that I've seen don't have specific custom provisions that are for that family. They're just sort of a boilerplate template document that is downloaded from some website. So that can be a real problem when it comes time to administer the trust after you've passed away. And I have seen errors in DIY trust documents that rendered them basically invalid, ineffective. And even if they're not ineffective, if there are errors in a trust, you may have to hire an attorney to correct a trust after death. And that can be pretty expensive and really stressful for your family to go through. It'd be a lot cheaper to hire a professional up front and get it done right, rather than let your family deal with issues after you've passed away occur because you chose a cheap way to get your estate planning done. So the 5th mistake that I see people engage in is using DIY trust documents. And that can be a real catastrophe for your family. Now, if you're thinking about setting up or revising a living trust, don't navigate this alone. Visit our website at smithbarid.com. That's B-A-R-I-D, like barid.com. Or give us a call to schedule a consultation and let's ensure that your estate plan is set up correctly and effectively. Thanks for watching. For more insights on estate planning and to ensure you're making the most informed decisions for your future, check out our other videos right here. Don't forget to like, subscribe, and share this video with others who might find it helpful. We'll see you next time.